All right, everyone, welcome to Fiveable and welcome to AP Government. Today, we will be reviewing Unit 3, which is Civil Rights and Civil Liberties. So this is one of the 3 units that's going to be covered on the AP exam. If you guys can hear me, if you just say something in the chat so that I know I'm not talking to myself, and then we'll go ahead and get started. So first, I want to talk about our weekly stream calendar. So as we move into AP review time, a lot of this stuff could be changing, but I still want to make sure that this consistent schedule is up. On Mondays, we have math and English. So we have lang and stats at 7, lit at 8. We have our weekly current events at 8:30, and then calc at 9. Social science streams on Tuesdays. So human, geo, and psych are before us, and then gov is at 9 p.m. Wednesdays are science, so environmental and physics are at 7, bios at 8, and chem is at 9. And then world histories at 8 p.m. on Thursdays, and then APUSH and AP Euro are both at 9 on Thursdays. So feel free to take a picture of this. This will be available again at the end of the stream, as well as on our Fiveable website or any of the recorded streams. Again, follow our AP Gov team. So Mondays at 8:30, we do a weekly current events and COVID-19 election update. So that's between Fatima and myself, who are both on the AP Gov team, and Brandon, who's on the AP Lang team. So we kind of rotate and switch off with who does that. That's always on Mondays at 8:30. Our free sessions are our free AP Gov sessions are 9 p.m. Eastern, and then our cram sessions kind of follow a different schedule. So if you are a Cram Pass member, you can see that schedule on the Fiveable website. If you are not a Cram Pass member, so far this is the last review or free review that we've scheduled, but that's why I put those 3 polls in there so that we could schedule one for the next 2 weeks before the AP Gov exam. Actually, it might just be next week because I think the next week is actually our exam. So again, if you guys could all answer the 3 polls that are on here so that we can start framing what we're going to do next week. As always, make sure to follow Fiveable on Twitter, Instagram, and YouTube. Also on TikTok. Brandon, who I talked about earlier, he's the one that runs the TikTok, so go follow him on TikTok and all of these other social media platforms. You'll see that we do an Instagram takeover once in a while, so it's specific to a subject, kind of like FRQ practice. So if you're into that or want to participate, definitely follow us on these platforms. A little bit about me. I'm a junior from North Carolina, and I love politics. I took it last year as a sophomore, and I got a 5 on the exam, and I'm super excited about Fiveable. So if you've seen me streaming, it's probably in Gov, current events, or APES, so I kind of do a little bit on the STEM side and the humanities side. So hopefully I'll see you again at another stream. So in terms of just an overview of what your exam is going to look like, everyone in the world is going to have to take it May 11th at 4 p.m. Eastern. So you can convert it to your time zone. But question 1 is going to be the argumentative essay, which is going to be 60%. Question 2 is going to be the concept application, which is worth 40%. So the argumentative essay rubric has been modified. If you go back a few weeks, I believe it was on the 6th of April or something like that, I did a Q&A session and went through how to write the argumentative essay. So if you want to get more information on that, you can see that on the Fiveable website. In terms of the units that are covered, units 1, 2, and 3 are covered. So basically, and I know I've seen some of you guys before, like I've said, they've kind of kept the AP US government and taken out the in politics part. The politics stuff comes up in unit 4 and 5, but the exam is going to be concentrated on 1 through 3. So we did the unit 1 review last week, and we're doing the unit 3 review today. So before we get started, like I mentioned, I think I emailed some of you guys, if you guys were registered before 4 p.m. today. I emailed you guys and asked you if you had any questions, you could fill out the link on the Fiveable community website. So in the future, if you ever have questions before a stream, you can just go down where that stream is and click on discuss and ask a question so that we could put those questions in our stream. So I believe Japesh is the one that had this question. And he asks, what exactly is double jeopardy? And if we have time, can we go over the basic differences between the types of courts? So double jeopardy is kind of related to what we're going to talk about today. A lot of what we're going to talk about today is civil liberties and the Bill of Rights. So double jeopardy is basically being tried twice for the exact same crime after a decision was already made. So let's say somebody committed murder for person A. They can't be charged again for the murder of person A. So if they were acquitted and then later new evidence comes up that shows they actually did murder that person, you can't go back and change that ruling. Now, let's say they murdered person A and then they were acquitted, and then they now murder person B. Obviously, yes, they can be tried for that second murder. They just can't. That decision can't go back and be reversed, if that makes sense, if new evidence occurs. I'm going to do a really quick overview of the federal court system just because I really don't think they're going to test you on that. But it is important to know. So in terms of the federal court, there are 91 district courts, which is the lowest level of federal court. Jury, there is a jury on those courts. There are 12 courts of appeal, so that's what you can see on this map. And the people that are doing the deciding are 3 judges. And then the Supreme Court, as you guys know, is the highest court in the land, and they have 9 justices. So in terms of district courts, there are 91 federal courts of original jurisdiction. That basically just means that they have the power to hear the case first, okay? And then you can just go through this slide. Again, we have 13 standards to cover, so I don't want to spend too much time on this, but you could always go back and watch the replay or the slides. They do not hear appeals, and they're the only federal court to have juries. Okay, so there's a question. Can someone still be tried by the same crime, but by the state and the federal government separately? So yeah, that's like an appeals process. So let's say I'm tried at the state Supreme Court for a crime, and it turns out that I don't agree with the decision. I can appeal the case or file a writ of certiorari and get it tried by the Supreme Court, right? So if it's still the same crime and you're still progressing in that manner, then that works. But you can't be tried for the same crime. Let's say if again, like I used with the example before, if someone murders another person and they're acquitted, if new evidence comes up later, they can't be retried, if that makes sense. Okay. Continuing on with the court system, 98% of criminal cases in the United States are heard in state and local courts, not a federal court, because in order for it to be in a federal court, they have to have committed a federal crime. And if you lose the case, you can just appeal to the higher court. I talked about those higher courts of appeal, so that's the second level in the federal government's judicial system. Each court serves at least 2 states and has between 6 to 28 judgeships. There's a panel of normally 3 judges, and basically here it's correcting errors of procedure and law. So not necessarily did he actually do it or not, but rather was he tried correctly? Did he get all of his rights? There's no trial or testimony for that reason. In terms of the Supreme Court, they have both original and appellate jurisdiction, mostly appellate, but they do have some original if a state is suing another state, stuff like that. Only the Supreme Court can decide. There's 9 justices, 8 associates, and 1 chief. And right now, so the balance I believe is 5-4 on the Supreme Court. So the conservatives have a majority right now. Very unlikely to get your case all the way up to the Supreme Court. You have to file a writ of certiorari, and it has to be really significant. So it has to do with a true question of constitutionality. So you might have heard the case Gideon versus Wainwright. That's an example of a case where a writ of certiorari was filed, and then it went up to the Supreme Court. So in terms of Unit 3 and civil liberties and civil rights, there's 13 standards that are on here. So the reason why I'm kind of going fast is because this has 70 slides because it's so long. Some of this stuff at the end is 1 slide each just because there's not much information, but a lot of this stuff is Supreme Court cases. So Supreme Court cases is a main focus of Unit 3. My guess is since they took out the Supreme Court comparison essay, they're going to include something about cases or some judicial proceedings just because they've completely removed that part when they're testing you on the Supreme Court cases. So I'm assuming there will be something on the concept application that relates to this. Last year, the argumentative essay on the exam was about Unit 1, I believe, Foundations of American Democracy. So again, we'll just see what happens with this. Since they're reducing the timings and everything, really we have no way of knowing what they're going to do. So in terms of Unit 3, this is like an overview of the standards. So 3.1 and 3.7 kind of go together. That's a Bill of Rights, and they're talking about selective incorporation. Then the next 4 standards are talking about First and Second Amendment. 3 standards are talking about right of the accused. And then this group of the last 4 is talking about social movements and then majority and minority rights. So this is the stuff that's really not as big or emphasized in this unit, but it's still important to kind of know and get a framework for your AP exam. So let's go ahead and get started. If anyone has any questions at any time, you could put it in the Ask a Question tab. You could put it in the chat, and I'll try to get back to you, talk about it as soon as possible. Again, if you're just joining, make sure you answer the poll, because that's gonna basically, I guess, decide what stream we do next week, because right now there's nothing scheduled for next week. So in terms of 3.1, this is talking about a general overview of Bill of Rights and the difference between civil liberties and civil rights. So this is something that I think is important to know, because those terms and vocab terms are commonly confused. Civil liberties are basically anything that you can find in the Bill of Rights. They're constitutional rights, and they protect individuals from the government. So some examples in the First Amendment: you have speech, religion, the press, fair trial. In terms of, and like I said before, it's just the Bill of Rights. In terms of civil liberties, those are the things that basically you're protected from discrimination based on your physical characteristics. So if you look at laws against racial discrimination, laws against gender discrimination based on nationality, any legislation that deals with that has to do with civil rights. Those aren't necessarily civil liberties, because it's not like you're having the freedom of speech, right? You're just being protected here against discrimination based on your literally physical characteristics. In terms of the history with this, there is something that you should know that connects back to Unit 1 with foundations of democracy. When the Constitution was going to be ratified, the Anti-Federalists were basically like, we're not going to do anything unless you draw up a list of Bill of Rights, because they were afraid that this was going to turn into a monarchy like Britain, and then we'd all be doomed again. So eventually, as soon as the Constitution was ratified, that was the first act of Congress, basically. They passed 10 amendments known as the Bill of Rights. And when the states ratified those amendments in 1791, that's when they became a part of the Constitution. So again, the Bill of Rights was designed to protect these liberties, and then civil rights kind of fall under that as you go along, I guess. And the other thing, so I accidentally moved on, but the Bill of Rights is a part of the Constitution. So let's say on your argumentative essay, they're like, use the Constitution as a piece of evidence or whatever. So they're gonna, give you a few documents that you have to use as evidence. If they say the Constitution, you can use anything from the Bill of Rights as well, because the Bill of Rights is a part of the Constitution. Any amendment to the Constitution is part of the Constitution because it's a change. Okay, so if that makes sense. I know last year that was a big confusion because people thought the Constitution was just the original document, but the Bill of Rights isn't a separate foundational document on your list. It's part of the Constitution. Okay, so before we move on into the First Amendment at 3.2, does anyone have any questions on 3.1? Okay, so I'm going to go ahead and move on to 3.2. Again, if you have questions, you could always put them in the chat. The First Amendment is going to talk about freedom of religion, speech, several other freedoms. So you have your acronym RAPS. So that's how you can remember them. So religion, assembly, press, petition, and speech. In terms of religion, there are 2 clauses in the First Amendment. Does anyone know what those are? Yes, establishment, and then there's one more. Free exercise is the other clause in the First Amendment that you should know. So in terms of the Establishment Clause, it creates a wall of separation between church and state. So if you've heard that division of church and state, that's where it comes from in the Establishment Clause. Basically, what the Establishment Clause says is that the federal government can't create a federal religion. So they can't make Christianity the religion of the United States. And basically they can't endorse any religion, and that filters down to anything that's federally funded. So public schools, all of those things cannot endorse religion. So we'll talk about a case, Engel versus Vitale, that deals with this. Generally, conservatives tend to support or tend to have more support for religion in politics and schools. Again, that is leaning more towards the Unit 4 and 5 that are not covered. However, all of these things are good context to have. So that was the Establishment Clause. The other clause is a Free Exercise Clause. The Free Exercise Clause is more in line with almost free speech, basically saying that each person has a right to believe what they want to believe. However, it does not allow illegal acts. So it's the freedom of religious thoughts, and you can exercise your religion however you want. However, if that exercise is a criminal activity, then that's not allowed. So that's just something to consider, I guess. Also, like I said, you can be legislated against, or you can be sued, or there can be a court case against you. You can be charged if those religious activities violate the any laws that exist. You are a criminal then, basically, if that makes sense. There are some court cases that relate to the First Amendment and religion. So the first one is going to be, if it loads, Engel versus Vitale. And then the second one is going to be Wisconsin versus Yoder. So before we get into Engel versus Vitale, does anyone know a synopsis of the case, what it's about? Right, group prayer in schools. And does anyone know what Wisconsin versus Yoder is about? So all of these cases that I'm talking about now, those cases are the ones that are going to be tested on your AP exam if they are. So Wisconsin versus Yoder is more in line with the free exercise, and yeah, Amish kids and whether they could go to school past a certain age. So Engel versus Vitale is a case in 1962. Basically, a short summary of this is that the New York Board of Regents, which is kind of like their school board, had authorized that at the beginning of the day, a short but voluntary prayer would be recited. So it wasn't going to be mandatory. You could say it if you want, but you didn't have to. But several organizations filed suit against the Board of Regents, basically saying that it went against the Establishment Clause because it showed that the federal government was praising a religion or advocating for that behavior. The New York Court of Appeals actually dismissed those arguments, so it ended up going on further to the Supreme Court. So this is what I think Rohan was asking, right? Yeah, before. So this was not necessarily a crime, but that case was tried more than once. So it was tried once at the state or local level, and then tried later at the federal level. So in terms of the constitutional issue that Engel versus Vitale dealt with, basically the prayer was voluntary and non-denominational. So it didn't adhere to a specific religion, and you didn't have to say it. However, it still goes against the Establishment Clause because it still advocated for the presence of religion and religious activity. So people that didn't have a religion or didn't feel that they wanted to participate in religious behavior might think that they have to just because this is happening. The end result was that states could not hold prayer in public schools, even if it was voluntary, even if it did not adhere to a specific religion, because the act of prayer itself is a religious activity. So that was kind of their logic in making that decision. Again, like I said, anything that's federally funded can have this applied. So since public schools are federally funded, that means that they can't advocate for religion. So that was the first case. The second case is Wisconsin versus Yoder. Wisconsin versus Yoder, again, like Sandra said, dealt with Amish kids and whether the parents would have to be forced to send their kids to school past 8th grade. So there was some kind of Wisconsin law that said kids had to attend school, right? Because if you don't, it's truancy. However, their religion did not agree with high school attendance or attendance past 8th grade. What ended up happening with the constitutional issue is that, again, free exercise clause. So really, is that need to have to go to school more important than the free exercise of religion to the Amish people? As you guys probably know, what ended up happening was that the requirement to send children to school beyond 16 or beyond 8th grade was held unconstitutional, And the individual interest in free exercise ended up being more powerful than the government's interest in sending kids to school beyond 8th grade. So this is an example where the individual's right was weighed more than the federal government's right. We'll see examples where it's the other way, and the federal government ends up winning. Okay, so there are cases that go both ways. So that's all for question 3.2. So we kind of answered this already. But does anyone have questions in terms of freedom of religion or those Supreme Court cases or rulings, etc.? Okay, so we're gonna go ahead and move on into 3.3, which is freedom of speech. So the first thing that this standard talks about in the College Board curriculum is symbolic speech. So again, a lot of these standards relate back to Supreme Court cases. What the College Board says is that symbolic speech is protected by the First Amendment's free speech clause, right? So the case that goes with this is Tinker versus Des Moines, and that's what we're going to talk about with this standard. And like I said before, there's efforts to balance social order and individual freedom, and that's reflected through interpretations of the First Amendment, not only through speech, but through religion, press. So whether the individual's interest in free speech or the freedom of exercise of religion, is that important? Or is the need to balance social order and the need to have the federal government have power? Which one is more important? Okay. The kind of like defining factors that College Board wants you to know is time, place, and manner, how it's conducted. So if it's free exercise of religion, is it truly like an exercise of religion? Again, if there are any offensive or obscene statements involved, etc. Okay, so that's like the main thing about the First Amendment. We're going to discuss several cases. So first Tinker, and then Schenck. So does anyone know anything about Tinker versus Des Moines? Right, students chose to wear armbands to advocate for peace, and those armbands are symbolic speech because they really didn't like say anything necessarily, but rather they displayed it. So they displayed it using those armbands, and right, it was protest against the war at that time. So a short summary of the case, like Alexandra and Japesh said, they were advocating for peace and protesting the Vietnam War. And they kind of wore these armbands despite warnings from their school administration and principals. After wearing those armbands, they were sent home because supposedly this was against their school rules or whatever. They couldn't advocate for stuff like this. Their parents, I believe, or the students maybe, sued the school district for violating their freedom of expression. So the First Amendment guarantees free political speech. So the students sued the school district for that. The main constitutional issue, and basically if you're asked about this on FRQ, this is probably what they would focus on. Did the prohibition against wearing the armbands or having that symbolic speech violate the freedom of speech clause? Okay, as you guys probably know, the result was that students do have free speech rights at school, and to justify the suppression of speech, it must substantially interfere with school operations. So if you look at a case, I believe it's called like something school district versus Fraser. I believe it's Bethel school district versus Fraser, something like that. Basically, the kid gave a super like inappropriate speech, and then he was expelled, and then he sued the school or the school district. It ended up going on the school district side just because that was actually substantially interfering with the school's operations. So if you're interested, look that case up. And like I said earlier, the right of individual freedom of that symbolic speech is more important than the potential disorder it could cause. One phrase that you might hear associated with this case is students don't shed their rights at the schoolhouse gates. If you ever hear that phrase, that comes from the ruling in this case. So those students that protested the war shouldn't have to shed their rights at the schoolhouse gates for the freedom of speech. So does anyone have any questions in terms of Tinker versus Des Moines? All right, so we're going to go ahead and move into Schenck versus the United States. One thing that I forgot to mention at the beginning is that if Crowdcast, like this platform, if it ends up crashing or if there are technical difficulties, I'll just do my best to reload. There have been some issues with Crowdcast the past few days, and like I don't know, technical issues, I guess. So if something happens and like I disappear on here, I'll just try to connect back as soon as possible. So like don't leave. I'll be back. Okay. So moving on with the First Amendment. Next, we're going to talk about the case Schenck versus the United States. So this is a case where the federal government's interest was weighed more than the individual's interest. So during World War I, several socialists, including Schenck, distributed leaflets basically advocating for people to disobey the draft. He stated that the draft would violate the 13th Amendment, and he wanted people to not go with it. Okay, he was charged with violating a law at that time, the Espionage Act of 1917, and he appealed on the grounds of First Amendment because he was saying that he should be able to advocate for whatever he wanted. So if he wanted to say that the draft was going against Amendment 13, then he could. So the question here is, did that act that charged him violate the First Amendment? And is this an appropriate exercise of Congress's wartime authority? So this is kind of a two-sided question. What ended up happening was that the act did not violate the First Amendment, and it was an appropriate exercise of Congress's wartime authority because of something called the clear and present danger test, which is a key limitation on the First Amendment. Free speech, the free speech clause does not allow for the advocacy of unlawful behavior. Just like you can't practice unlawful exercise of religion, you can't practice unlawful behavior and claim it's under free speech. So that's where the phrase clear and present danger comes from. If it causes a clear and present danger, then it doesn't necessarily go with the First Amendment. So if you guys could answer this in the chat, fill in the boxes 1 and 2 with the appropriate Supreme Court case. Yep, 1 is Tinker, and yes, all of you that said that, correct. 1 is Tinker, and then 2 is Schenck. Because Schenck went with the federal government, Tinker went with the individual. Okay. So next thing that we're going to talk about is the other freedom in the First Amendment. So before we do that, does anyone have any questions for Standard 3.3, which was freedom of speech? Okay, so let's go ahead and move on into the freedom of the press. So some words to know and some commonly confused words are going to be libel and slander. Libel is written defamation, so anything that's actually written, and attacks a person's name or reputation. The key thing here is that there has to be a proof of malice. That's really hard to prove, and it's really hard to prove that it's intentional, which is why it's hard to like sue someone for libel. Slander is basically the same thing as libel, except it's spoken. So those are like, I guess, two different ways that you can go against someone if you wanted to. In terms of prior restraint, that's just limiting the freedom of the press by preventing publication. There is a case that goes with that. Does anyone know what case that is? All right, so we're going to go ahead and talk about one of those cases, which is the New York Times versus the United States. Correct. So it is known as a Pentagon Papers case because of what it involved. Basically, the Nixon administration was trying to prevent the New York Times from publishing specific and supposedly classified material. The Defense Department had conducted a study about U.S. intervention in Vietnam, and Nixon said it was really necessary to national security to prohibit that from being published. So that was kind of his reasoning. And again, this ties back to that term of prior restraint. Okay, the constitutional issue at stake here was whether Nixon's administration's prior restraint, so restricting that publication, was constitutional, and if preventing the publication of classified material was a violation of the First Amendment. The First Amendment guarantees free press. If this is happening, is that truly fair and actually going with what the First Amendment says? And like I said, this goes with freedom of the press. So what ended up happening and what the constitutional principle and the holding was that the Supreme Court bolstered the freedom of the press through this ruling. basically they said there was going to be a heavy presumption against prior restraint, even for national security purposes. So there has to be obscenity or immediate and direct danger to national security for them to invoke prior restraint. So he said in this case that was not there, so they couldn't really restrict that publishing. So really 3.4, all that was the Supreme Court case, which was New York Times versus the United States. If you have any questions, again, go ahead and put that in the chat. But we're going to move on into the Second Amendment and the right to bear arms. So as you guys probably know, the Second Amendment is one of the more controversial amendments just because of its split among political parties. Okay. So if this goes on. Okay, so the decisions on the Second Amendment rest upon the constitutional interpretation of liberty. So that's kind of the quote, the big words that College Board uses. What that's saying is really nothing special. It's just like every other amendment. Okay, there's a conflict between public safety, what's good for the public, and individual rights, which is again a common theme, right? So depending on what happens with every Supreme Court justice and how they rule, that constitutional interpretation of liberty and that right to bear arms is going to differ, as is this with the conflict between safety and individual rights. So we'll talk about some specific selective incorporation cases that deal with Amendment 2 later. But this is, again, all that College Board asks you to know with that standard. So does anyone have any questions about the Second Amendment? All right, so let's go ahead and get started for 3.6, which is balancing individual freedom with public order. So this is a common theme. Like I said, we've seen across probably every standard that we've done. There's always been a conflict with this in the judicial branch and like which way they should go. So some people, the population generally favors the individual freedom, but the government generally favors public order because that's uniform and across all people. That's just something to consider always. The two examples that we're going to talk about first is going to include the Eighth Amendment. So the Eighth Amendment has interpretations involving cruel and unusual punishment. So there's a difference at the state level in terms of who supports that and who doesn't. In terms of the Second and Fourth Amendment, there is public safety in terms of guns and privacy, and then should the government have control over firearms, the collection of warlike data. So after 9/11, the government has the authority through several pieces of legislation to collect a lot more of our technological data than before. So again, that's just something to consider with the Second and Fourth Amendment. We're going to talk about that in a little bit more detail in just a minute. So with the Eighth Amendment, opponents of the death penalty use the Eighth Amendment to justify opinion. So the Eighth Amendment is kind of going at the extreme. So it's saying no cruel or unusual punishment, and then no excessive bails or fines. The death penalty, people that oppose it obviously say that it's a cruel and unusual punishment, and that therefore you should not do that. There have been limits by the Supreme Court on when the death penalty can be applied. However, it's still constitutional, so it's still legal in the U.S. If you want more information about how that came to be and the concept of the death penalty, you can check out this case, which is Gregg versus Georgia. I'm not going to go into detail with that, again, just because this unit is the one with all the required Supreme Court cases. So I want to be able to focus on this. One thing that I think maybe you'll see with the concept application is like a political cartoon. Generally, I guess that is almost a quantitative analysis sometimes. Like it tends to fit in better with that since the quantitative is about a graph or a picture. But yeah, so get good at analyzing political cartoons. Maybe look up some stuff about how to analyze a political cartoon in case you're asked to do that for the concept application. So at the beginning of this standard, I said we're going to talk about the Eighth Amendment and then the Second and Fourth Amendment in terms of guns, and then Fourth Amendment in terms of privacy. So like I said, after 9/11, we had a huge increase in the power given to the federal government. So there was a creation of the Homeland Security Department. So that was part of the cabinet, the president's cabinet, and of course still is today. There was much more government involvement in investigations and prosecution of suspected terrorists, etc., in the United States. one key piece of legislation that College Board mentions is the Patriot Act. So the Patriot Act increased federal powers in investigating potential terrorists. So whether that be through tapping phones, voicemails, if there's a court order. So that's something to think about in terms of the Fourth Amendment. The Fourth Amendment says there's no unnecessary searches and seizures. So like, does this fall under that? Again, it's all a debate. And like I said before, it's all based on the constitutional interpretation of courts at that time. So that could easily change from time to time. You know, generally courts tend to follow precedent or stare decisis, but not always. Like, it always reverse precedent. So again, just something to think about as you prepare for your AP exam. So that was 3.6. The next standard is going to talk about selective incorporation. So does anyone know what selective incorporation is, or have any questions on anything we've done so far? Right, it does have to do with the 14th Amendment. Any other thoughts on like what it does? Or like what clause or constitutional clause that involves, etc.? Right, so it's how courts make decisions and implement rulings on a case-by-case basis. And the most important thing is that they're making the Bill of Rights applicable to the states. So I saw, even recently, I think it was like in the past few weeks, that a clause of the Sixth Amendment had been selectively incorporated. So this is stuff that's happening like consistently. Just last year or the year before, the Eighth Amendment was selectively incorporated. So again, this is happening over time and over a long period of time. So it's not just all the Bill of Rights at the same time. So originally, the Bill of Rights did not apply to the states, okay? But through the case, Gitlow versus New York, the freedom of speech and press were declared fundamental and therefore protected by the Due Process Clause of Amendment 14. So one thing that you'll find is common with all of these selective incorporation cases is that the right is deemed fundamental, and then it's protected by the Due Process Clause of Amendment 14. So if they ever ask you about selective incorporation, the correct answer is Due Process Clause. They will not accept Equal Protection Clause. So just make sure that if it's about selective incorporation, the answer is Due Process Clause, not Equal Protection. Equal Protection, that's like Brown versus Ward, that type of case. Okay, so through Gitlow versus New York, that started like the tradition of extending requirements of the Bill of Rights to the states. So like Japesh said, it happens piece by piece on what's called a piecemeal basis, okay? Not all at the same time. So not all 10 amendments and all their clauses were incorporated at the same time. In fact, some of them have still not been incorporated. So the first case that we're going to talk about that dealt with selective incorporation is McDonald versus Chicago. Does anyone have any idea what this case entailed? Or like anything about the case, like amendment that it dealt with? Yes, Second Amendment and owning a gun, making the right to bear arms applicable to the states. Yes, you guys are correct. So in a summary or as a summary, I don't know what's the right word, but Chicago passed a handgun ban law, and several suits were filed against the city challenging the ban after another case in Washington, D.C., which was called D.C. versus Heller. The court had held that a D.C. handgun ban violated the Second Amendment, so it had kind of happened in D.C., but I believe it was a federal court since it was Washington, D.C., and it hadn't been applied to states yet. So that's what McDonald versus Chicago is trying to do. So in Washington, D.C., since the law had been enacted by the federal government, it didn't really deal with that Bill of Rights piece yet. But this one did because it was in Chicago, not in D.C. So the applicability of the Second Amendment to the states was argued, and whether the Second Amendment's right to bear arms, which is interpreted as an individual right in D.C. versus Heller, also applied to the states. So individual right, like I said before, in all of these selective incorporation cases, they're going to say something about that right or that liberty being a fundamental or an individual right, and it being applied to the states through the 14th Amendment's Due Process Clause. Okay, so it's almost like you could fill in the blanks if you're asked a question like that. In terms of the holding and the constitutional principle, The court stated that the handgun ban was unconstitutional in a 5-4 ruling, and they said since the right to self-defense was fundamental, the Second Amendment was incorporated to the states. So again, through the 14th Amendment's due process clause. So always, 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 if you know it's a selective incorporation case, follow those steps or outline that for yourself. Okay, it's always those few steps. Okay, so hopefully that makes sense. And now we're going to move into 3.8, which is talking a lot more about rights of the accused. So does anyone have any questions about that? Or what we talked about? Okay, so let's go ahead and get started with 3.8, which is rights of the accused. Again, if you're just joining us, please fill out the poll. I'm really emphasizing this just because we don't currently have a free review scheduled for next week. I believe next week is the last week before your AP exam, because I think your AP exam is the next Monday. So we really want to schedule something for next week. So if you fill out the poll, then we'll be able to use what you said to guide what we do, I guess. So please fill out all 3 of those polls that are there. So one of them is which unit are you most comfortable with, which one are you less or least comfortable with, and which FRQ are you most worried about. All right. So 3.8 is talking about due process and the rights of the accused. And the first theme in here is restricting individual liberty. You'll see that I've said like this conflict or this almost dichotomy between individual liberty and public safety or public order or social order is a consistent theme throughout almost every standard. So we saw this in Schenck versus the United States, where the Supreme Court sided with the federal government and said, if there's a clear and present danger, that's not allowed, right? So one thing that you want to remember and probably have heard before is the Miranda warning or the Miranda rule. Basically, it's saying that you have the right to remain silent, but there is a public safety exception. So kind of two-sided, I guess. You can see the full thing right here, but the right to remain silent. What that means is that you're protected from self-incrimination. So you can't be forced to say something against yourself. On the other hand, let's say you say something about yourself, but there's truly like a danger to public safety and like, you know, it's like a big case and that applies, then there is an exception to the Miranda rule. So again, you'll see that there are exceptions here when there is like a true danger to public safety. So we saw that with prior restraint. We saw that with free speech, with the exercise of religion. Again, consistent theme throughout this entire unit. The other thing that I wanted to talk about is more with the amendments. So in terms of pretrial rights in the 4th Amendment, there's a prohibition against unreasonable searches and seizures. The exclusionary rule basically says that illegally seized evidence cannot be used in trial. So if they don't follow that rule, which says you can't search and seize without a warrant, and then they get evidence that goes against you, they can't use that against you in trial because of the exclusionary rule. So the first time the exclusionary rule was applied was in the 1914 case, which was Weeks versus the United States. Now, I had never actually heard of this case before I was researching for today's stream. However, the case that you guys probably know and I'm more familiar with is Mapp versus Ohio, which was when the 4th Amendment was incorporated to the states through the Due Process Clause. So remember, each of the amendments had to be incorporated, and Mapp versus Ohio is the one that did that to the states. Mapp is not one of your foundational or your required Supreme Court cases, so I wouldn't expect that they would ask you about that. But they do mention the exclusionary rule, so it might be good to have some context on that. Other pretrial or like trial rights for the accused in the 6th Amendment and a little bit in the 5th Amendment, we learn about the right to legal counsel, a speedy and public trial, a fair, representative, impartial jury of your peers. All of those are guaranteed. And then protection against, this one it seems almost kind of out of place, but I included it because it was in College Board's curriculum. So there's a protection against warrantless searches of cell phone data. So that's something, again, you can talk about with the freedom of speech. So they kind of included this in 2 places. Again, it's not really a pre-trial right, but it is important to remember that with increasing technology comes more issues of involving the right to privacy. Okay, so the other terminology that you want to be aware of with due process and the rights of the accused are 3 terms that are probably some hard AP Gov terms that you've heard in either U.S. history or you've heard reference in a vocab list somewhere and kind of forgot about. I highly doubt they'd ask you about this if they're limited to asking 2 FRQs for the entire year. However, again, it's good to have context. Habeas corpus is basically when the prisoner knows what they are in prison for. As you know, like Lincoln, he suspended it during his presidency. When that happens, it's considered like an overreach of power. A bill of attainder, that's something that provides for the punishment of a person without a court trial. Now, the Sixth Amendment guarantees a free trial, right? So a bill of attainder is prohibited by the Constitution. Ex post facto law. This is a law that's applied to an act committed before the law is enacted. So let's say, I don't know, I paint a pencil red, okay? 2 days after I do it, they pass a law and they say, there's a law prohibiting all pencils being painted red, right? They can't go back and then charge me for painting this pencil red because I painted it before the law actually happened, right? So that would be an example of an ex post facto law being applied to something that's already happened. So again, that's also prohibited by the Constitution. And that kind of ties in with that double jeopardy stuff that we were talking about at the beginning. So this is a pretty famous case, and I'm sure you've probably heard of it. There's a really good documentary on YouTube, I think, if you haven't watched it, about Gideon versus Wainwright. A summary of this case, basically, this guy, Gideon, was charged in Florida for a felony breaking and entering charge, and he requested that he received a court-appointed lawyer. However, in accordance with Florida state law at that time, only people who were charged under a federal case or a capital case could get an attorney appointed to them by the state court. So this was, again, kind of like a federal thing. In terms of what a capital case is, it's a prosecution case for murder in which a jury is asked to decide whether a defendant should be put to death or not. So that's the only time when they were allowed to get lawyers, if they were in state court. However, Gideon was like, that doesn't make sense because that's not what the Sixth Amendment says. So the Sixth Amendment and the constitutional issue here is whether the right to counsel guaranteed in this amendment also applies to felony defendants in state court. So again, incorporating what the federal government said to the states. So what happened with Gideon versus Wainwright was that the Sixth Amendment's right to counsel does apply to state court defendants through the 14th Amendment's due process clause. Again, this key phrase that I've been talking about, the right of counsel is fundamental, and that's why it's incorporated to the states through that due process clause. So yeah, that's something you should know. This part of the Bill of Rights now applies to the states. Again, you'll see how only the right to counsel was extended to the states, right? So it happens piece by piece, not all at the same time. So this is a good example of how not even the entire Sixth Amendment was incorporated, just that tiny little bit that Gideon appealed. Okay, so that was 3.8. Does anyone have any questions on that standard? All right, so that's it for 3.8. Now we're going to move in a little bit more with amendments, but to the right to privacy. So you guys probably know there's no like Bill of Rights or no amendment that specifically says all citizens have their right to privacy, right? It's not specifically mentioned in the Constitution. However, the due process clause is interpreted as implying this right. And there's several ways where other amendments can apply to the right of privacy, including 1, 3, 4, 5, and 14. So 1 guarantees the freedom of religion. So that's like, I mean, I guess a private thing. That one doesn't apply as much. Number 3 prohibits the government from quartering, like forcing citizens to quarter soldiers in their homes. 4th Amendment protects citizens from unreasonable searches and seizures without a warrant. 5th Amendment prohibits private property from being seized without due process of law. So I think, or eminent domain is what that is. And then 14 is a due process clause, right? So all these amendments kind of tied together present a general right to privacy. Okay, so that's what is discussed on that slide. A case that goes with the right of privacy is a famous case and recently a little bit more controversial case. So that's something that College Board mentions is that it's still being debated in modern times, is Roe versus Wade. So Roe versus Wade, Norma McCorvey, who is Jane Roe, so that was like her like nickname or whatever, like it's not the public name that they put out with the cases. She wanted to have an abortion, but she couldn't legally have one in Texas at the time because they prohibited abortions except in cases where the mother's life is in danger. So the legality of that law was questioned in the case, and the constitutional issue was in several cases before this, the court had ruled that the Bill of Rights creates what are called zones of privacy in 1, 3, 4, and 9. Now the court had to decide whether a woman's right to privacy fit within those zones, or that broad right to privacy. Because there is no explicit guarantee of the right to privacy, it's kind of difficult to guarantee that sometimes, and that's why it becomes controversial. But in the previous case, they did guarantee privacy through those zones. So that's what the constitutional issue was here. So what ended up happening, as I'm sure you know, is the implied right to privacy. So the court ruled that the abortion or an abortion is within that implied right, and they incorporated this fundamental right to the state. So here, they actually incorporated a right that's not explicitly mentioned to the states, and this actually expanded the definition of privacy. Okay, so that was all for 3.9, and that was really the last big standard. The next ones are pretty small. So does anyone have any questions on anything that we've covered so far? Okay, so I'm going to go ahead and move on into social movements and equal protection. So remember at the beginning, we talked about the differences between equal or civil rights and civil liberties. Civil liberties is what we've talked about so far. Anything that's guaranteed by the Bill of Rights. Civil rights are things that protect individuals from discrimination based on their physical characteristics. So this could be race, gender, sexuality, national origin, religion, all of those things fall under civil rights. So it's guaranteed, or these civil rights are guaranteed to citizens through due process, equal protection, and legislation. So the previous civil liberty stuff is guaranteed through Bill of Rights and Selective Incorporation. Here it's a little bit different, and this relates to the Equal Protection Clause. So last year on the Supreme Court comparison case essay, the first question was like, Brown versus Board of Education was the case they were talking about, and the first question was, which clause of the 14th Amendment does this go with? And the correct answer was equal protection. If you said due process there, that was counted wrong, right? So you have to make sure you know these two clauses apart, just like establishment and free exercise, all of those things. So some examples of the Equal Protection Clause and how they work include civil rights, which includes your foundational document of the letter from Birmingham Jail, women's rights, and some like more in terms of women's rights, like pay and the modern equality movement, voting, etc. So I'm going to talk a little bit just about some of these things. So first I'm going to talk about civil rights, and going back to the history of racial equality. So the Dred Scott decision in 1857 basically established the principle that national legislation couldn't limit the spread of slavery. A few decades later, in 1896, Plessy versus Ferguson said separate but equal. So if the facilities were equal, like in, I guess, aesthetics and the way they function, etc., that was okay as long as they were equal, but they could be separated. So segregation could occur. Finally, however, in Brown versus Board of Education, they reversed that. They said separate can never be equal, and that's when they desegregated schools. In terms of women's equality, a key piece of legislation that they want you to know is Title 9, which I believe we're going to talk about on one of the later slides. But some other things that you want to know about is that women's rights activists were very disappointed when the 15th Amendment failed to grant women the right to vote, right? It wasn't until the 19th Amendment that women could vote. In 1972, there was something passed, or almost passed, called the Equal Rights Amendment. Okay, so this was a proposed amendment to the Constitution, and it basically said equality of rights in everything. So it cannot be denied by the United States or abridged by the United States or any state on account of gender. This actually fell 3 states short of that 3/4 that's necessary for ratification. So this would have been an amendment to the Constitution where it said men and women are equal in all aspects. However, this amendment did not go through with all state legislatures. And now there's some more push for that to happen again. The Civil Rights Act of 1964 prohibited discrimination in employment based on race and sex. The Equal Pay Act of 1963 requires employees to pay women and men the equal pay for equal work. Obviously, that wage gap still exists. It's like 81 cents or 78 cents for every dollar. So women earn like 81 cents for every dollar that a man makes. So, we're still not there yet. In terms of going back to the civil rights movement in your argumentative essay, one thing that you should know about is this foundational document, the letter from Birmingham Jail. The letter from Birmingham Jail is probably, for me at least, it was one of the more confusing foundational documents because it is so long. What I would recommend you do is print out an abridged version or a summary. I'm sure there's something like on SparkNotes or like lit charts that could help you with this, and make some kind of one pager so that you can use it on your AP exam. So with what Martin Luther King was doing, some background. He was arrested for parading without a permit, and he spent 11 days in Birmingham Jail. This letter was in response to a joint statement released by 8 Alabama clergymen. And basically they said ending inequality should be done in courts. And they said there's responsible citizens that are actually working on realistic approaches. And they said there's hatred and violence happening, and that comes from religious and political reasons. Okay, so the letter for Birmingham Jail actually establishes that foundation for nonviolent action, which we know Martin Luther King for. So in terms of what King said, these are some important quotes and details that I picked out. He said, injustice anywhere is a threat to justice everywhere. He said that slaves waited 345 years for freedom. Isn't that long enough? And he discusses this idea of an unjust law is no law at all. So like, for example, Hitler's actions were legal in Germany at the time. However, it was an unjust law. So should that really be considered a law? Right? And he talks about the emotional toll it's having on young children. He used an example of his own children. And he forced everyone to confront racial issues head on. Okay. So that was a summary of that foundational document that you need to know for your AP exam. Again, I would recommend that you actually read it yourself so that you know what is stated in case that is tested on your argumentative essay. Basically, the two ways they could test civil rights and civil liberties on your AP exam is either through your argumentative essay and this being one of the documents, because I'm pretty sure this one and the Constitution are the only foundational documents that are in this unit. So they could test it this way, or they could test it in your concept application with anything else. Okay. In terms of government responses to social movements, there's several ways that has happened. I talked about the Civil Rights Act of 1964. And I mentioned we were going to talk about Title IX and the Voting Rights Act of 1965. What Title IX did with was the full name is Title IX of the Education Act of 1972. It forbids educational institutions receiving federal funds from discriminating against female students. So this actually helped develop female athletic programs in universities. So before that, because many colleges, they didn't really establish that kind of women's athletic program, because this law said you can't discriminate against women, and basically if you do, you won't get federal funding. That caused the development of many female athletic programs. The Voting Rights Act of 1965 outlawed literacy tests and other kind of discriminatory practices that had been responsible for not allowing African Americans to vote at the time. And later, so after the Voting Rights Act, the 24th Amendment prohibited, well, actually, I'm not sure if this was before or after, just because the date where it was, the date of 1965 might be the time when it was passed or the time when it was in Congress. But the 24th Amendment, which I believe was advocated for in 1964 and eventually was passed around that 1965, so all within that range, prohibited poll taxes. So this was kind of, again, trying to make sure that there was equality between African Americans and whites in terms of voting. Okay, so that was 3.11. But 3.11 also talked about court cases and how that can help with what they do. So, or what the government response is. Brown versus Board of Education is one of the most famous cases in U.S. history. You probably heard this a million times, but it dealt with racial segregation of schools. At that time, African American students had been denied admittance to public schools, and many argued that this was in violation of the Constitution. The constitutional issue here, again, was an equal protection issue Previously, like I said, Plessy versus Ferguson had held that segregated facilities were legal as long as the facilities were equal. So separate but equal is what they said. This case ended up reversing that. Uh, the Supreme Court ruled that separate but equal is inherently unequal, and they said that segregated schools allowed by the previous Plessy case um, were declared unconstitutional. So this had a huge impact on our country. It required the desegregation of all public schools, any school that was federally funded. So one of the most impactful and most known Supreme Court cases in our history. These are some key concepts that go with this. I'm not really going to go into detail with this because this is really like Unit 2, but I would recommend going through those when you go back and review Brown versus Board. In terms of the next standard, 312, this is talking about balancing majority and minority rights. So there have been court cases, pieces of legislation, etc., that have restricted and protected minority rights. So one example I've already talked about with African Americans getting restricted access to the same facilities as the majority white population. Here, the rights of the majority were strengthened. Well, first they were weakened through Plessy, but then that was changed with Brown versus Board, and eventually the rights of the minorities were strengthened. In terms of another example with this and how the strengths of the majority were strengthened is gerrymandering. So there have been court cases, pieces of legislation, etc., that have restricted and protected minority rights through gerrymandering. So in 1990, several state legislatures created like really weird districts. They were shaped oddly, and it was clear that the motivation was race. So minority voters would get their representative in, like numerically, they would be able to elect whoever they wanted. Remember, drawing state districts is all done by state legislatures. So generally, if it's a Democratic legislature, they will draw them to favor them. If it's a Republican legislature, they will draw them to favor the Republicans. So that's something to think about. One of your court cases is not mentioned in the College Board for this unit, but you should know it, is Shaw versus Reno. That's talking about majority-minority districts and how in the future they must be held to strict scrutiny. Basically, in later decisions, if race is the prominent or predominant factor, those districts can be declared unconstitutional. So you'll see several cases about that later. So I've talked a lot about basically strengthening majority and minority rights and Brown versus Board, etc. Does anyone have any questions about that? So any of the past few standards that I've talked about. Okay, so the last standard is going to be 313, which is affirmative action. Affirmative action is just a big word for remedying past discrimination by the government and requiring federal agencies and universities and employers to take that into consideration when they select job applicants or admissions or like students for admission at their university. Some justices say that the Constitution is colorblind and doesn't reference that. Some say it forbids racial classifications that are designed to harm minorities, but it doesn't forbid those that are designed to help. So affirmative action technically helps minorities. So that's some people's arguments. So some arguments for affirmative action are that it helps make up for those past injustices, and it would help increase the number of women and minorities in desirable jobs, and that's important. Some arguments against affirmative action is that it can create reverse discrimination that unfairly penalizes like people that are in the majority. And then critics also say that laws and policies should promote equal opportunity, not equal results. So equal results is kind of what affirmative action goes for, making sure that minorities like are able to get jobs or get government positions or get into universities. However, equal opportunity, on the other hand, that's making sure everyone has the same resources in order to hopefully achieve equal results without like government intervention like this. So those are some of the arguments against affirmative action. Again, I don't think this will probably be a topic that's tested on this year's AP exam just because it's a small topic. But yeah. So we talked all about Unit 3, 13 standards. We talked about Bill of Rights, Selective Incorporation, First and Second Amendment, rights to the accused, social movements, majority-minority rights, and then we talked a little bit about the structure of the judicial branch at the beginning. So does anyone have any questions with anything Unit 3 related, AP Gov related, fileable related. So like it doesn't have to be something that I covered in this stream. It could be literally anything that we've talked about ever. If not, that's all I have. So you guys are free to leave if you're good. I'm good. Remember our weekly stream calendar. We are going to be streaming Tuesdays at 9 p.m. I will use these suggestions that you guys had in terms of the units you're most comfortable with, units you're not comfortable with, and the FRQs to try and come up with a plan with my Gov team. Well, not my Gov team, the Gov team and some of the other humanities streamers to do something for next week and maybe the day before the exam as well. If I don't see you guys again in future streams, good luck on your exam. I hope you guys are doing well and staying safe. As always, remember we have current event streams every Monday at 8:30, at least for the next 2 weeks. And then we stream at 9 p.m. For reviews. So as always, remember to follow Fiveable on Twitter, Instagram, YouTube, TikTok, every app, all the same handle. And if no one has any questions, I'll stick around for like a few seconds. If no one has any questions, that's all for me. All right, everyone. Thanks so much. Have a great night.